Okay, Chapter 6, Video 9, or Part 9, we're dealing now with negligence defenses. Assumption of the risk is a important defense. It's defined as the plaintiff knows the risk and voluntarily engages in the act anyway, and therefore may not recover from the alleged tortfeasor. Okay, so typically this occurs in a situation such as a slip and fall case. If you're walking in Kroger and somebody before you tried to get a bottle of cooking oil and instead dropped it on the floor, broke the bottle, and now there's cooking oil creating a slippery area, and you don't see it because you're looking up at the shelves and you walk into it, you probably have a cause of action for negligence against Kroger if they knew about the area on the floor, or should have known about it and didn't take appropriate action. On the other hand, if you're walking down the aisle and you see that oily spot and you walk through it anyway, not concerned about it, then you've assumed the risk, and that's a defense for Kroger. It's an absolute defense in many cases. So it can be either express or implied. So assumption of the risk is important. In a lot of cases when you do activities like rafting or things like that, where you have a company that's taking you, you may be assuming the risk. Application to baseball is very interesting. Traditionally, if you were seated along the outfield area and a baseball came and hit you, courts ruled that you assume the risk because people know that at a baseball game you are likely to, there's foul balls and they might hit you. That's why they put screens behind home plate. Some states are taking newer looks at this, and because of the nature of the game and how it's changed and how fast the ball goes, they are now looking at it more as a sort of strict liability type of thing, expecting baseball parks to put screens up all the way down the field. So that's an interesting area. If you run into a situation like that, you're probably going to want to do research because it is sort of a developing area, and you can see what I've got on this slide about that. Okay, another defense is where there's a superseding cause. Something intervenes between the defendant's actions and the plaintiff's injury that actually causes the injury to the plaintiff. It has to be unforeseeable. If it's foreseeable, it doesn't matter. Okay, so example 6.28 on page 130, I think is probably not the best representation of a superseding cause. I would urge you to read this Powell case at 209 Georgia Appeals 348, and that is probably a better example of a superseding cause as a defense. Contributory negligence was a common law doctrine that was used as a defense, and that basically said that if the plaintiff was also negligent and that contributed to the injury, then the defendant was not liable. So it was an absolute defense. Virtually every state has done away with contributory negligence because you can see by its very nature it tends to be unfair. So even though the plaintiff may have been slightly at fault, suppose the plaintiff is driving down the road, has the right of way, the speed limit is 30 and the plaintiff is going 35. The defendant runs the stop sign, runs into the plaintiff. In some states that used to apply contributory negligence, the plaintiff could not recover because they were going over the speed limit, and that's negligent. You can see that that's probably not fair in that circumstance because of the nature of what each party did. So most states have done away with that and now use comparative negligence. And comparative negligence basically leaves it up to the jury to compare the negligence of the two parties. And the plaintiff's damages are reduced by the amount that the plaintiff was viewed to have been liable. So if the jury feels that the plaintiff was 20% at fault and the defendant was 80% at fault, the jury calculates what the damages would have been if the defendant was 100% at fault, and then reduces that amount by 20%. Okay, now different states use different rules. Some states use the 50% rule that say that the plaintiff can only recover if they're less than 50% responsible. Some say use the 51% rule that the plaintiff recovers nothing if the liability is greater than 50%. This comes into play a lot of times, particularly in medical malpractice cases, because you can have a medical malpractice case, for example, where the doctor may have done something wrong in let's say, a surgery, and the doctor, when the patient was discharged, the doctor maybe didn't even realize that they did something wrong, and the doctor, as is ordinary practice in that kind of surgery, gives the the patient, a prescription for antibiotics and says you need to take all these because of the possibility of infection from the surgery. Well, the plaintiff fails to take those antibiotics. The nature of the negligence by the doctor leads to an infection, and the person has their leg amputated. Okay, so the jury determines that, based upon the facts, that there's a 95% chance that if the person had taken those antibiotics, they would not have developed the infection and they wouldn't have had their leg amputated. The damages for the leg amputation, the jury decides, is $1 million. So in the situation, the jury says, well, the patient was 95% liable for not taking the antibiotics, the doctor 5%. The person's still going to get 5% of $1 million. A lot of places see that as unfair and have adopted this 50 or 51% rule, which basically acts more like contributory negligence and says that the plaintiff can't recover at all under those circumstances. Okay. So that ends this chapter. I believe the next chapter we get into the other torts of intentional torts. And remember that the magic word for chapter 6 is duty.